I'm Sarah Trott, and welcome back to the Fourth Trimester podcast. I'm here with special guest Patricia De Fonte, and we are going to talk about estate planning and protecting your family and your legacy. So, Patricia teaches a course on this. She's a very experienced estate attorney, and she has agreed to share with us the information that she shares with new and expecting parents as they get ready for putting their estate plan together and creating a plan that works for them and their family. And so I'm really excited to have you on the show today. Welcome, Patricia.
Thank you so much. There is just not a soapbox that I won't fight my way to the top of to get the news out about estate planning. There are a lot of different ways to do it, and I'm all about best practices. And a best practice means being fully informed and knowing what your options are. So I'm excited to get into this today.
Patricia, will you tell us a little bit more about you, who you are, your background, what inspired you to do this?
Sure. So I am of and from San Francisco. I was born here, and this is still very much my home. I have two sons who live the city thoroughly. They are older teenagers now, and I'm married to my husband. I opened my own practice 8 years ago, and I got really lucky when I was learning about estate planning because I've been a lawyer for over 20 years, but this isn't my first act as a lawyer. When I decided I wanted to move into estate planning because I didn't want to litigate anymore, didn't want a combative adversarial approach to my work once I became a mother. It was just not suitable anymore. So I wanted a practice area that was collaborative, where I was really helping people um, in a way that would make them happy. I decided to go back to school. And while I was in school, in the master's program, the amount of money that you can have before you have to pay federal estate tax doubled to, for a single person, 11.5 million and 23 million for a married couple. So we really stopped talking so much about tax, and we really started talking about how do we help. And we help by spending time. We help by listening. We help by providing referrals to other practitioners, whether it's insurance, a different kind of lawyer, a CPA, a financial advisor. We help by asking a lot of questions and issue spotting with the client so that the estate planning documents that we create are not just in a void, that there is a full plan to cover every contingency that we can possibly spot so that people can really rest easy, because a stack of documents is just never the plan.
No, no, definitely not. And since you're a parent, would you be willing to share a little bit more about your own fourth trimester experience?
I had two fourth trimester experiences, very different. My first son was diagnosed in utero with a cleft lip and palate. And knowing that you're going to give birth to a child that is immediately going to need medical intervention, a lot more assistance, will not be able to nurse, will need special bottles. And there are a lot of potential health problems. The 1 in 1,000, 1 in 500 has additional things. We got really lucky. My son just has a cleft lip and palate. But birth, his birth was awful, and I'll spare everyone the horrible details. But I stayed in the hospital for 5 days. He was down the hall in the NICU. And I am certain that I had postpartum depression. I was getting in fights with everybody in line at Lucky's, at Gymboree. I was just like, really, it was not good. My second son, who was born 22 months later, I had a planned C-section. So I knew it was going to happen. I was out of the hospital in 36 hours. He was an angel baby. And everything went really easily. I really got to see the difference between being in that fourth trimester when nobody sleeps, because my son could not self-soothe. So he was just up and awake crying all the time. Um, and then having a child who slept in long stretches for weeks on end and just very, very different experience. And so now the one thing that I always ask new mothers is, are you sleeping? Because it was the sleep that made the difference. And if somebody will offer to do anything, people who say, just let me know if you need anything, I need you to come over and be in a room with my baby while I sleep. I don't care what you do, but just make sure the baby is fine and do not wake me up. That would be my hot tip for everybody in the fourth trimester. Try to get as much sleep as you possibly can.
Yeah, that's a wonderful tip there. And, we've had a lot of people echo kind of the theme around get support in various ways and also the importance of sleep. Because if you're not sleeping, then kind of nothing else can really work out very well in terms of your mental health and getting stable. And so I appreciate you mentioning that. And we'll keep that in mind for our listeners. So tell me more about estate planning. Where do you usually start the conversation? How does that work?
There's always, making sure that we're the right lawyer. So there's a 20-minute meeting where we talk about my firm's approach. Um, we are 100% virtual. We leverage technology to streamline, but we don't leverage technology to do the real work. So we're tech forward, but we're also asking clients for a lot of their time. And so, and because of this, we are not inexpensive. And so we start off with a 20-minute meeting just to make sure that we're the exact right perfect lawyer. And we're not always the exact right perfect lawyer, but I don't think it takes more than 20 minutes to figure that out. Once we get to the first substantive meeting, we start out with softballs, because we have to build a lot of trust. And, at my firm, we're doing it through a screen. But I think any good estate planning lawyer is asking you questions to get you to feel calm and safe and kind of in a state where you can answer the harder questions or ponder the harder questions, feeling that someone's really listening to you. So, for my couples who are clients, I want to know how they met. I want to know about their pets. It's really fun in California to ask people about their gun collections because most of them just laugh. Or they say things like, I have a gun from the Revolutionary War and it's at my great aunt's house in Massachusetts, but it's mine. There was just no gun culture here, really, um, among my client base. Asking a lot of soft questions, and then we'll move into let's talk about insurance. Now, your insurance is not generally part of your estate plan, right? Insurance is ancillary, but if you don't have umbrella insurance, if your homeowner's insurance isn't adequate, if your auto insurance isn't adequate, if your policies don't mesh and you have gaps in insurance, your auto policy will pay out up to 500,000, but your umbrella doesn't kick in until 750, well, you've got a $250,000 gap. I don't really feel like I'm doing my clients a great service if I don't point out to them that they need to go and do a complete audit. When we have clients who are relying on their employee benefits for disability and life insurance, those are wonderful employee benefits, but they're not really durable. Sometimes you can take them with you, but they're going to cost a lot more. Sometimes you can't take them with you when you change jobs or you're fired or you retire. So we ask all of our clients to do that also. So we'll talk about pets and guns and how you met. We'll talk about insurance. We want to talk about who does your taxes. Do you have an investment advisor, a financial advisor? If you have a business, who is the lawyer who assists you with that? So we want to make sure that all of our clients have a great team around them. I can't be my client's only advisor. I'm an estate planning attorney. I don't know how to sell anybody insurance. I don't want to know how to do that. You certainly don't want me managing your investment portfolio. I have no qualification to do that whatsoever. But things are going to happen through time and through life. And when we're thinking about people who are just having a baby, that's a huge change in your finances and your insurance. So many different things are happening. It's really important to have a great team of advisors that you can rely on when there's opportunity, when there's change. And then, of course, when bad things happen, you want to be able to call the right person. Then we get into the stuff. And, it's funny because clients will try to tell us which assets are important. Every single asset is important. If you have a bank account back in Wisconsin that has $200 in it, it is just as much trouble for the people left behind to deal with that account as it is to deal with an account that has $2 million in it. We need to know absolutely everything so that if you hit your head or when you die, things are streamlined for your people. We don't want these outlying extra doodads here and there. Um, and some people get through the money discussion. It's really easy. this, that, the other, this money, that money. Other people, it's emotional. And for some couples, it can be really emotional. Um, I'm a California lawyer, and California is a community property state. Sometimes people get very upset when they say, "This is my bank account." And I say, "Where did the money come for that bank account?" "Well, I work and I put my money in there." "Do you have a prenup?" "No." So in California, if you're married and you're putting your wages into a separate bank account and you don't have a prenup, that's not yours. That's that belongs to the community. So sometimes we can get a lot of feelings during the asset review. Not all the time, sometimes. By the time we've gotten to that point, we're about 45 minutes into the meeting. And then I throw a big curveball and I say, okay, we're changing completely what we're doing. Picture yourself in a coma. Who is this person who loves you, who is trustworthy, who is strong, can stand up to family and doctors? Who is this person that will pull the plug if that's what you want them to do? And it's really fun because it's a big jolt. And because I want to go straight to like one of the hardest things. It's like, we've done kind of the easy stuff. Now let's jump in and really picture yourself vulnerable, which is hard. It's really hard. And when we're working with clients who are pregnant or very close to postpartum, it can hit really hard. It's a tough one when you know that you're going to be going into the hospital or you've just been in the hospital because for some people, you go in the hospital, you have a baby and it's fine. Other people really feel like they have been hospitalized and they have a different relationship to these questions than people who hadn't had that experience. But then we give them a little break. Why don't we get up and walk around a little bit, stretch a little bit? The last part of the meeting is really about who gets what and who's in charge. So we've asked our clients a lot of questions about themselves, their families, who they love, who they trust, who freaks them out, who they're worried about. And so we have this list of assets and we have this list of people. And, we're thinking on our end, and when I say we, I have two lawyers who work for me. So we're thinking of maximizing the taxes. We're thinking of matching assets and people from a technical perspective, but that's not good estate planning. What we really want to do is have that mesh with how do we do this for these people? If we're worried about these people, how do we get the biggest bang for our buck to take care of the people that we want to take care of? So that final part of the meeting goes pretty quickly when we're thinking about who gets what when. Like, Charlene, you said that you were really worried about your mom. Do you want to leave your mom a gift when you die? And sometimes Charlene will say, no, no, no. Mom will talk to my spouse. Will she? Would mom actually go to your spouse and ask for money? And most people, no, no, she would never. Okay, so let's think about leaving a gift for mom. Let's think about leaving a gift for a sibling who maybe has some substance abuse issues. Maybe we want to leave some money for recovery for them. Because it's not always everything to the surviving spouse or partner. It's not always everything to the kids. Sometimes we're worried about other people. Because if we're leaving assets to our kids, what we want them to grow into is a healthy, happy family. And it's not fun for a child to have a whole bunch of money if grandma is struggling financially, right? They're going to feel that. Um, a child doesn't need $1.2 million when they could have $1 million and $0.2 million could go to Uncle Jeremy's recovery, right? We'd rather have Uncle Jeremy than the money. And then we stop. And it's really fun because clients, by that time, it's been about 2 hours. They're exhausted. But we remind them we're not holding you to any of this. We think maybe these people are going to be in charge. And we think maybe these people are going to get gifts. And here's what we're worried about if we give them a gift. We're going to go away with this information and we're going to draft documents for you. And then the clients are happy. Like, oh, good. The way that we approach it is a little bit different than most attorneys because most attorneys won't draft until they know exactly what the client wants to do. In my experience, the clients do better at the next meeting when we show them the draft documents. Here is the job that you're asking someone to do. Can they do this job? Let's double check who we've chosen. And then let's talk about the gifting that we talked about in the first meeting. We took a stab at it. We think this would work. You know your people. What did we miss? What did we get right? How does it need to be tweaked? And that's when clients, because now they really understand the documents. It's like, we've explained the document to you. You've double checked that, yes or no, is this the right person? Now let's talk about, is the document itself, the operative parts of it that are specific to you. Do we get it right? And the clients have so much ownership over, is it right? Because they actually understand the document. We're not talking about it as, this imaginary plan. It's not just a one-page flow chart. It's real now. Um, Usually we get it right. Say about 10% of the time we go back in for heavier lifting. Um, we let our clients sign online or in person, and then we have a final meeting, which I think is critical. And if clients have a financial advisor, we want that advisor to come to the meeting. And in the meantime, we have probably talked to their financial advisor, their corporate counsel, maybe we've talked to their CPA, because all of these people have different perspectives and concerns about what they want to see accomplished for the client. But it's important to have the financial advisor, if they have one, at this meeting, because we're talking about, how do we get this stuff into the trust? So a trust has a list of your stuff at the back. This bank account, this piece of real estate, I own this company. But that list of stuff doesn't mean that it's already in the trust. You actually have to go and do the paperwork for each one of those items. It is very boring. It is very technical and it takes time. But most of my clients are young. And so we're going to force them to do it. And we force them to do it because inevitably something will change. They're going to change jobs. They're going to move. Their bank is going to fail. That's a popular one, very popular in the last couple of years. We're really putting them through their paces so that they understand what they need to do every time there is a change. And mostly the thing that they remember to do is email me to ask me what to do, which is perfect and good and fine. Um, but I just realized that I didn't really explain what estate planning is. Um,
Yeah, I was going to jump in and ask you, do you find that a lot of people taking your course or coming to you really understand what estate planning is and why it's important?
No, they do not. Well, most people who have had a baby know that they need to do it, and their big concern is guardianship. And then they're completely surprised by the rest of it. Estate planning is three things. It addresses three questions. What about me? What happens if I hit my head, if I lose capacity? Who gets to make healthcare decisions for me? Who steps into my shoes to act as me when it comes to my money, my insurance, running my business, dealing with my taxes, dealing with my employer? So that's one piece. And here in California, as soon as you turn 18, everybody needs these documents. This is, you graduate from high school, you have to sign these documents because nobody has the right to make healthcare decisions for you. Not your parents, not your spouse, not your partner. No one is automatically in position to make those decisions for you. And absolutely nobody can talk to your employer or your landlord or your, the mortgage company. Nobody's allowed to do that. And, everybody's always calling Comcast and PG&E and impersonating their spouse or their partner. Please don't do that with the federal government. Please don't do that with the IRS. So that's the first part. And that is addressed with advanced healthcare directives and durable powers of attorney. Advanced healthcare directives you can do on your own. You don't have to pay anybody to do this. You should never pay some online product to do an advanced healthcare directive. It's unnecessary. There are statutory forms in every state, and you just Google the name of your state, advanced healthcare directives statutory form. Your local librarian can help you also to find this. And many of the medical centers also have classes that they do. And it might be that it's an in-person class or a Zoom class, or it's kind of a one-on-one tutorial that you go through online. And then you're filling out that entity's version of the form. All of these are great options. But take a couple notes because most of them are concerned with who's in charge, pull the plug or don't, donate my organs or don't, bury me or cremate me. And there's not much else there. If you're pregnant or planning to be pregnant, you want to put in a lot of information about how you feel about pregnancy. And it can be hyper particular, one of the things we address is if I am outside of California, I want to be brought back, because we know that women's reproductive rights in other states are wanting. It can be about viability, gestation periods. It can be hyper specific. I mean, if we're doing them that hyper specific, we also want our client to talk to their doctor. Um, if you have people in your life that you can't stand and you don't want anywhere near you in the hospital, you should write that down. If you do not share a religious affiliation with your partner or with your parents, write down what is supposed to happen. Is it okay for clergy to visit you? Do you want to be buried in accordance with the tenets and traditions of the faith that you were brought up in? Make it really clear. Make it crystal clear, because one of the worst jobs ever is serving as someone else's healthcare proxy. It's awful. Nobody wants to be making these decisions, and nobody wins. So you don't want to leave anything to chance. You want to provide more and more and more and more information. If you're a member of the LGBTQIA plus community, your healthcare directives should have very clear requirements that your proxy find healthcare providers who are welcoming and proficient in working with that community. If you have a service animal, we want to make sure that we list that you want your service animal to visit you and be with you for emotional comfort. You can really just go completely crazy. And in California, you can write your advanced healthcare directive on the back of a napkin. You can use any form you like. I like to start with the statutory form, because if you're thinking of the medical community reading through it, that's the one they're used to seeing, and then you can just add lots of bells and whistles, and there are lots of spots where it says actually add extra pages, and you can just write whatever you like and just add it, and then have it notarized or have a couple people witness it. The
Okay,
other
so that's
part
question 1, right? Like what happens to me?
Yeah, and the other part of what happens to me is a durable power of attorney. There is also a California statutory form for that. You wanna have that notarized. The trick is the banks. The banks are looking for that signature by a lawyer. So if you do this on your own, they're going to try to reject it. So if you're doing this on your own, I would say bring it to your banks and say, I have this document. I'm putting it on file with you. I am fine. I'm making this choice and I'm giving this to you, because they're afraid that, duress or fraud, they're afraid to let somebody else do your banking. And then they kick it up to legal. And then, $10,000 later, maybe your person has been able to get into your account. So I would say it's really important to go to your banks, and maybe they have their own form that they want you to fill out, or they will accept the form that you're giving them, and then you're in a better position if you were unable to have a lawyer countersign. But I ask my clients also, please take this to the bank with you and show it to them, because the banks are irrational, and they'll just say policy, 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 and make things difficult. So that's what about me. The second part is what about my stuff? And here we're talking about people who have children, because we're talking about the fourth trimester. It is very difficult to do an estate plan during the fourth trimester because you are so tired. I would really, really encourage anybody listening to this who's pregnant to just start working on it now. It's easier now. Um, what about my stuff is, how do we make sure that your stuff gets to where it needs to go? The kids, a surviving spouse or partner, other people that you're worried about or you love or you want to honor or who you owe money to, um, in a way that avoids the court process. Because once you're in the court process, which is called probate, everything is public and everything winds up on the dark web. So what we don't want to do is draft a long will that says who gets what, because then everybody knows who got what, and they're not safe, right? Here come all the creeps and the creditors and the predators and all the weirdos, and everybody's got a great idea for a business or wants to marry them. A trust keeps everything private. A trust also gives you control from the grave. So if you think that money should be used for a specific purpose, you can say that. When it comes to leaving money to children, minor children, the old way was you get your money when you're 25, 30, and 35. And until then, you get money for health and maintenance and support and education. This is old, boring thinking. Imagine yourself at 35 with no parents. and millions of dollars. Probably not going to have a terrific outcome if you're just getting everything all at once. We prefer to approach this by saying, we're your parents and we love you, and we want you to have a rich and robust life, and we want you to pay these values forward. Travel is important, family is important, art, aesthetics, sports, all important parts of a well rounded life. Come and ask for money whenever you want it or need it, and we'll see. You'll have a discussion with the person in charge, and they'll make a prudent decision. You want to start a business? Maybe. You want to buy a house? Maybe. Because it's going to be in conversation. Can you afford this house? Can you pay the mortgage? Is it insurable? All of the other things, right? Because anytime somebody wants to buy a piece of property, they just get all hot and they want the piece of property. But we're going to slow it down a little bit. And then instead of saying you get your money at certain ages, we say at intervals. Once both parents are gone, you have to be at least, let's say, 26. You're going to wait a year so that you get used to the idea. And then we're going to give you some. And then a few years later, we're going to give you a little bit more. It's a very different approach. We take a very conservative approach to giving people money. It doesn't mean the kids can't access their money. They can ask the successor trustee to pay for their education. They want to go visit their grandmother in Guatemala. The trustee can pay for that. They want to start a business. The trustee can pay the business formation lawyer out of the trust. We're not cutting people off, but we are cutting people off a bit from cash, because cash is where beneficiaries get in trouble because of all the people who come around, because inherited money feels bad. And so people tend to give it away. So we're protecting our clients' children from the outside world, but we're also protecting them from themselves, from their own best instincts and frailties and weaknesses. Because what we want are financially savvy beneficiaries who have lawyers, financial advisors, and CPAs that the trust can pay for so that they make great moves with their money.
So the parents are finding someone, identifying someone, naming someone who's a family member or a trusted friend to help manage that on behalf of their children.
Exactly. Exactly. And in most old trusts, there's one name. The successor trustee is Beatrice. We do it a little bit differently. If you bump your head, maybe Beatrice is the right person. But once you've died and this person has to do a whole year of heavy lifting, dealing with the banks, a final tax return, um, it's it's a lot. Maybe they have to sell a piece of property. It just goes on and on and on for about a year. The trust administration, the settling of the estate. Maybe Douglas is the perfect person for that. He's older and it's a good place for him to bury his grief, and he's super organized. Maybe he can be there. But then when it comes to who's managing the money for 15, 20 years for the benefit of the kids and has a great personality and a good rapport with younger people and will really listen and can follow instructions and will do this job over a period of years, maybe that's a different person altogether. And so we really have to peel that onion. And that's why we ask a lot of questions. Who do you love? Who do you trust? And I even say, you told me who you love. Now, sometimes the people we love, they can't find their way out of a paper bag. So from this list, who's responsible and reliable and trustworthy, can keep a secret. So
And then
that's,
if someone doesn't have a trusted person, if they don't jump up and say, oh, of course, it's my brother, it's my sister, or whoever it is, if they don't have someone, are there professionals who can be hired and trusted for this kind of role?
yes. And usually we do this one of two ways. Is there's someone who they absolutely trust, but they don't want to burden that person with the job. And so we can, let's say it's Francine. So we are going to say Francine is the successor trustee, and her whole job is to work with a lawyer to find a private fiduciary who is going to do the work. And that's usually for clients who are on overload and just do not want to go interview a bunch of private fiduciaries. I just can't get them to do it. And then every once in a while, there are clients who just say straight out the gate, it has to be a private fiduciary. I'm not burdening anybody with this. And that one person that you're thinking is perfect, you really have to go and ask them, because if you think they're perfect, everybody else thinks they're perfect too. And they might say no to you because they're already on deck for so many other people.
Yeah, I mean, it would be kind of surprising for something to happen and then start getting phone calls like, "Hey, you've been named as this person," because they must be informed beforehand, right? You can't just surprise someone with this role.
Well, you shouldn't. You should not surprise someone with that role. And I've gotten a few calls from clients over the years that said, "Hey, this person in my circle has passed away and they name me as the successor trustee. Do I have to do this?" I just tell them, no, no, you don't have to do this. You really should. Um, I have a successor trustee manual that I give to clients. And so I'll send them one of those and say, look at the amount of work and then think about the people that you're going to be involved with while you're doing this. So, it's your aunt, and now you are supposed to be in charge of distributing money to your cousins. How does that feel? And most people say that feels really bad and I don't want to do it because they're all going to hate me. Well, there's your answer. Don't do it. And so you're always looking at, so maybe so and so from a technical perspective would do a bang up job with this, but they're a jerk. Or the family dynamic can't handle that, right? So you wouldn't want to name that person.
Yeah, for sure.
So then
Okay.
there's the third part, which is, what about my kids? So the old way of naming guardians is a couple of names in a will. So an estate plan for children always needs to have a trust for minor kids because minor kids can't inherit. So you need to use a trust. But that doesn't mean you don't also have a will. The will should be just a technical document that says, "Hi, Your Honor, here's my marital status and the number of children that I have so far," and letting the judge know that you have a trust so the judge can just stamp this part of a will and put it in her outbox. Most lawyers will use that document to name guardians. The worst one I ever saw had the children's full names, birth dates, and social security numbers, and the guardians' names, phone number, email, and home address. When you die, that document becomes public. Will wind up on the dark web. This is not a good situation for a surviving spouse or, it's their surviving parent. It's not a good situation for the kids or the guardians. Here in California, we are allowed to use a separate document. So at my firm, we do. You get to appoint the people in charge of you, and you get to appoint the people in charge of your stuff, but you nominate the guardians of your children. So when you think about this judge who all of a sudden has this problem on her desk, put yourself in her position. What kind of information would she like to have to determine what is in the best interest of your children? Probably more than just a few names on a piece of paper. So we get into, here's who we don't want and why. And usually it's aging parents. We love our parents. We want them to be grandparents and emotional support and not have to figure out education or address discipline, right? And then we get into where we want the children to live, what kind of school we'd like them to go to. Should they have access to social media? We'll do a list of people who are very close to the family. Here's a list of people that we love that we want our children to spend time with. Now the judge knows who to go and talk to, right? Because we can't just assume that the people that we've chosen are going to be the right people if the time comes. Because maybe Chris and Pat were perfect. But then if that time comes, Pat's mom is in hospice and it's not the time, or they're getting a divorce, or one of them is got a fellowship and they're going to go live in London for a year, right? People are always doing things and living their lives. And so what's appropriate now might not be appropriate later. So you always want a judge's set of eyes to determine what is the best case scenario for these children right now. And that really surprises people because they think, well, I wrote it down and that's how it has to be. No. And even when we do these really long forms, clients will say, so this is what people have to do, right? They have to take my kids to see their grandfather twice a year. No, they don't. They don't. Once they are appointed as the guardian, everything is up to them. Divorced people understand this beautifully because the new guardians have full legal making authority and just like personal authority. They have all the authority, make all the decisions. Um, so it can be a little bit scary, but this document is the cutest and sweetest of all of the documents because people really they'll list their values and their traditions and the why, why they're choosing certain things can be really, really touching. We want our children brought up in this faith, even though only one of us is in that faith, because we looked at this other faith and we feel as people that it should be this way, like just really from the heart, sweet, touching stuff. I love it. Yes, I practice law and it's sweet and touching. It's so much
I mean, it
fun.
sounds a lot more detailed than the kind of estate planning templates I've seen or thought about. If you just kind of Google around on what's included or what kind of questions. I mean, this what you're talking about is a lot more detailed.
It's a
And it's raising a lot of questions, right? Like, what happens? I mean, it kind of points to the fact that if you're not talking about this stuff, you're leaving a lot to chance or you're letting other people fill in the blanks for you.
Absolutely. If you do nothing, then each state has its own rules. Here in California, the rules are you don't have incapacity documents in place, conservatorship. The judge is going to appoint someone who's going to make decisions for you, period. That is done in open court and it's traumatic and it is expensive for everybody involved. If you do not address estate planning, there are probate codes that say who gets what. And then a judge will decide if there are minor children involved, when they get their money and how. Judge might not even have any kids. Um, in New York, the judge decided for James Gandolfini that his daughter could have all her money at 18. It's James Gandolfini money at 8. It's crazy. Terrible, terrible results. And then with children, here in California, children are placed where it's necessary and convenient. So a relative comes over and they seem perfectly fine. The officer who's shown up at the door that day says, okay, that looks good. Or they can't find anyone, Child Protective Services. And once they're in that system, very difficult for a very loving aunt or grandmother or best friend to get them out of that system. So it's I don't like to talk about the scary parts of estate planning that much. Try to motivate people through empowerment and creativity and, really building a beautiful roadmap for a family. But the reality is if you don't take care of it, it's terrible. And I don't want to see another GoFundMe online for this. I don't want to see this. I don't want to see it.
Yeah. And then do people typically list more than one person to help look after their children if they've passed?
A judge is not going to appoint two people who are not a couple as guardians. So you can't have like your best friend and then your partner's cousin. They would need to get married to each other.
Yeah.
So because it's not practical, right? It's not practical. And so it's usually a married or partnered couple or a single person.
Yeah, that makes sense. But if they're like, what I mean is, do people list backups? Like, if this is my first choice,
Oh,
but if they can't do it, if Chris and Pat can't do it, then who's my backup? And then who's the backup for them?
I
Like a
like
list.
two backups for everything because we just never know what people are going to be doing. And then when you think about women in the sandwich generation, we have our kids and we have our mothers. Maybe we would be very willing to do to do the trust administration for our best friend, but it's not something we actually could do when the time comes if we are helping our parents downsize dealing with an illness in our own family. It's, we try not to name older people, but sometimes even within our generation, so many caregivers, we can't take care of everything and everyone. And so I like a nice deep bench. I think it's important.
Yeah, thank you. I agree. So then what are the critical things that you'd want to share and make people understand about, like, obviously we've covered what estate planning is, the big three questions that it answers. We've talked about why it's important and like what else do you really want to impress upon people?
Please do not try to do this on your own. If you work with a lawyer who has malpractice insurance and make sure that they do, if there's a problem, later there's money to help resolve that problem. If you try to do this on your own on ChatGPT, if you try to use one of those online products where it asks you questions and then you type in some answers, there's no malpractice insurance to help you. And some of those products will say, oh, and you can ask a lawyer questions. Um, I doubt that you know all of the questions that you need to ask. And there is not a lawyer there issue spotting. There's not a lawyer there asking you all of the questions, asking about the relationships among the people, asking the questions that are going to push us towards the answer to, will this plan work? Will it work for the people involved? Will it work if we name these people? So I know that it is enticing because it seems so inexpensive, and you see the ads online, blah blah blah.com. It's so easy. We loved it. It only took an hour. This is not what you want from your insurance, and not what you want from your financial advisor, and not what you want for your estate plan. You want committed professionals who are going to work with you to create a plan that works for you and your family, not some cookie cutter nonsense that's not backed by malpractice insurance. It just enrages me that they're allowed to get away with this. And so many of them say, created by a lawyer. Okay, well, I drafted a beautiful plan yesterday for a client. Should I just go ahead and use that for you? I've never met you and I've never talked to you, but it's a perfectly wonderful plan. Can't we just use that? You would be furious at me. You would say, no way, lady. Um, so I don't see why just the fact that it was drafted by a lawyer somewhere, not even for someone, makes it the appropriate vehicle for you and your family. It just drives me up a wall.
Yeah, for sure. So, Patricia, thank you so much. One of the things that came to mind was that if someone's concerned about the price tag of hiring a professional to that end, they could talk about that with parents or loved ones who are willing to give them gifts. One of the things that we've heard other people recommend is if you're doing your baby registry, you can ask for funds to help pay for support that's critical for you. So if you know you really want that sleep consultant, right? By the way, based on your story, sleep
I
consultants are
wish
a
I had
thing.
one.
I'm
Not
mentioning
just
it
someone
because
to hold him while I slept.
if anyone's listening that, oh, well, and there's night doulas, that's also a thing. But if you know there's services that you want, maybe you want body work, maybe you want money for other kinds of support, maybe a little extra housekeeping, for that first year when baby's really little, you need that help. You can ask people who are giving you gifts, hey, instead of that onesie, contribute to my fund. This is going to help pay for my estate planning, right? This is going to help do something that's really important for me and my family.
I love that. When we think about estate planning for women, our own estate planning is very important. Protects us, protects our kids. The estate planning for people who are adjacent to you, your spouse, your unmarried partner, your parents, anybody who thinks that you're going to stop your life to go and take care of them, they owe you up to date, fully funded trust documents. They owe you terrific insurance. Um, it's exciting to get married and then you have a baby and then you're buying a house. And all these things are happening all at once. And it's really easy to skip over great insurance and skip over the estate plan and those things that build that nice protective shield around you and your family. It's not inappropriate to really push your spouse or partner to do this, to make sure that the life insurance is all set up, and never take everything's taken care of seriously. Just do not accept that as an answer. If you're not both sitting in front of a lawyer and working through all these things, if you're not both sitting in front of an insurance agent and working through this, if you're not both sitting in front of a CPA or a financial advisor and working these things through, you haven't done everything that you really need to do to make sure that you're completely protected.
Yeah, great. Any final words you want to leave with our listeners?
Just want to thank everybody for caring about estate planning. I know that it feels overwhelming, but I promise you that it can be really touching and bonding and empowering. Uh, you do not have to have all of your ducks in a row. If you don't have the insurance in place, you don't have the financial advisor, all of that. If you work with a great lawyer, they're going to make sure that all of that is cleaned up by the time that you are done working with them. The only thing you need to have in place to get started is the desire. You just have to be ready to jump in with both feet. You don't have to otherwise prepare in any way.
Great. Patricia, where can people learn more about you?
Sure. So, my firm, we do workshops every month through a wonderful nonprofit in San Francisco called Natural Resources. And those workshops are free. Big part of our pro bono mission is education. I also have a YouTube channel. Um, and my website has a lot of information on it. And you can Google estate planning with heart, and we're really easy to find. And from estateplanningwithheart.com, you can get links to everything else.
Great. We'll put links for all of that in our show notes as well, including links to natural resources. We're such a fan of them and their resources. We love to mention that they have retail in person. They also have online, on demand, and virtual courses. So, in theory, those are available worldwide, and we would love for everyone to go and take advantage of them. So, thank you so much again, Patricia. I really appreciated the conversation.
Thank you so much for having me.